Good morning, everyone. Happy snowy Tuesday and welcome back after the winter break. My name is Amanda Perazio. I am the Chief Human Resources Officer here in Jefferson County, everyone. And snowy Tuesday. I'm glad to see everyone here safely. And for those of you who are driving and listening, please do so carefully. For those of you who are working and listening, please do so carefully. And for those of you who are still warm at home, please have a nice day and stay inside. Trust us. We would like to welcome the teams back to the negotiations table after our winter break. Happy New Year to all of you. Happy New Year to those of you who are tuning in. Before we get started, we would like to go around and do introductions. And so I already introduced myself. So let's start with Jen and go that way. And if you could just say your name and your role in JESPA, that would be great.
Jen Christensen, the Director of Labor Relations. Sarah Smith, Preschool. Nikki Saunders, Health Tech.
Xander Kashub, JESPA President.
Darcy Hassler, Paraprofessional and JESPA Bargaining Chair.
Tiffany Beestrom, Paraprofessional Public.
Vicki Flores, JESPA Staff.
Ken's Director of Fleet Services.
Brandon Root, Manager, Dispatch Operations.
Katie Jeter, Director of Resources for Food Service. Thank you, everyone. And joining us is Suann Holly, the Director of Early Learning. And we will go ahead and move forward. We have a couple of team members who are still joining us as they are driving in after dropping off kiddos and trying to do so safely. So our agenda, I'm gonna share my screen so that viewers are also able to see the agenda. So our agenda, as on the screen, we had our welcome and introduction scheduled, and then we have 3 language proposals from each side of, or excuse me, 3 from the district and 4 from JESPA. And those articles include 10, 12, and 13, and then 1, 2, 8, and 9. We do have caucus time scheduled as well as a question and answer time. I believe we do want to add in a couple of things. We wanted to discuss facilitation, and then there's a scheduling conflict that we need to review on January 21st. And then of course, at the end, we will set the agenda for January 14th. Darcy, is there anything else that you wanted to add to the agenda?
There was something that we left from last time on the recorded sessions on how to access them. And I would like to thank Jen that she got right back to the team on that they are on there, but for everyone's knowledge, I would like to say that they aren't on the Jeffco Board Negotiations website. Instead of scrolling down to the bottom where all the different years are listed, it needs to be the top button that says View JESPA Negotiations. And then now they are all YouTube. So that was our mistake, as we all just scroll down to the bottom to see previous ones, but they are at the top. On the left, it says JCA, on the right, it says JESPA. And when you go in that link to YouTube, then they are there or are being put there for previous years. So I just wanted to acknowledge that Jen did that right away and let us know that it was there. We were just looking in the wrong place.
Great, thank you, Jen, and thank you to Drew, who's behind the scenes, re-uploading all of those after transitioning to YouTube instead of our previous version of live streaming. The other thing that we were going to add to the agenda just escaped your mind, I can tell. It was scheduling on January 21st. I would also like to welcome Jessica Goodkin, one of the directors of special education, who has just joined us, trying to make people not have to quickly turn on the mic. So any other agenda adjustments before we get started?
We would like to propose a 20-minute caucus after you do your language before we do ours.
Sounds great.
And just, we're not gonna do ours 1, 2, 8, 9. I don't know if that needs to be fixed, that we're gonna do it in a different order, but I just wanted to call attention to that. And one's gonna be very fluid, and we'll talk about that when we get there.
Sounds good. All right. Any other items before we get started with language?
Again, sorry. On our teams folders. We have all the articles, we don't have appendices. And one of our articles refers to an appendix. So I don't know if we want to put that in the article or just have a way to submit an appendix on our team's channel. I just wanted to. Jen, I tried and I'm not saying it's anything that's set up wrong. It's a me learning Teams and I was unsuccessful. So I'm asking for some support there, Jen.
Is the one I will choose because it is Purple Week. I've claimed it Purple Week. I'm a Baltimore Ravens fan. So you know. Okay, so we will go ahead and get started with Article 10. Our approach would be to put it up on the screen and to not read through the entire article unless you would like us to, but to read through the proposed changes that we have identified. So I think I have to switch. So our first article that we would like to present for red lines for consideration is Article 10. Article 10 is our professional behavior and corrective action article. This is, you're doing it. Okay, sorry, I got confused for a second. So Article 10, we would like to propose switching the title of this article from simply corrective action to professional behavior and corrective action, because it really does address both throughout the language. So we have indicated that change both at the title and in the first heading. In 10.1.2, we have proposed switching the language from discipline to corrective action. We've done that a few times throughout this particular article. In the second piece of due process. So due process, you have reply, notice, representation, and appeal. In the second piece of notice, we've made some suggestions. The right to be notified of a potential corrective action, including the topic of the meeting. We left in 2 workdays prior to holding the meeting in order to have adequate time to prepare. So just kind of simplifying it and being more specific around the fact that it would be potential corrective action and that the topic of the meeting would need to be given, of course. In 10.1.2.3 under representation, we have struck the language or an adverse evaluation is delivered. Later on in this article, you'll see that we have suggested moving the language around evaluation out of this article and into the evaluation article. In 10.1.4, again, we switched. Instead of adverse action, we use the word corrective action. In 10.1.3, just cause, in the very first section under adequate warning, we simply changed the language from employees will be informed of rules and policies to employees will be informed of the kinds of misconduct that may result in corrective action. As you all are aware, sometimes misconduct may be against a rule, against a policy. It also may be against a law, against a reasonable responsibility, etc. And so we just wanted to include that word as that section of kinds of misconduct. In that same section under just cause, under 10.1.3.5 and 10.1.3.6, we just had a minor change. Equal treatment, all rules, policies, and penalties will be applied equitably and without discrimination. So we just changed the word even-handedly to equitably. And then 10.1.3.6, instead of saying in Article 10, we just said in this article, since it's the article that this language lives in. Again, in 10.2, performance management, we have a suggestion to move this language to Article 9. Therefore, we have not made any specific red lines to this actual language, except to lift it all out, move it to 9, and then once we get to 9, we can review those potential modifications. In 10.2, under employee misconduct, we have covering my screen. In 10.2.1, first, I'm sorry, I forgot to note, throughout we have renumbered, and we know that in the end, Jen will fix all of it and make all the numbers beautiful. But we have, because the following did not seem to be actual steps, note that last sentence that says the procedure for progressive discipline will include the following steps. So these aren't really steps, they're just kind of a description of what it might look like. The first paragraph being around prior to issuing formal reprimands, the restorative practice should happen. And instead of using the EAP or district restorative practice staff, we put the appropriately trained district staff. We know that both the EAP, the restorative practice team, and others are trained. I want to make sure that we are not exclusive and just those teams. In the next paragraph, we have taken out the language, a letter of concern. I feel as though a letter of expectation and a letter of concern really are one and the same. And oh, I'm sorry. Just right. Okay. You're welcome. So we took out the letter of concern and we're proposing not using that particular type of letter anymore. It's not used very often anyway. And then just very simply, under the formal discipline process, we changed the word where appropriate to when appropriate. In 10, what would now be 10.2.2, we added in some language. So this now reads, in cases of intentional violation of district policy or commission of a felony, the employee is subject to suspension, demotion, or immediate discharge. All three of these things could be true at any given time, depending on what the severity is of the action. We suggested removing the Article 10.2.3, 10, whatever that was previously numbered. So the district may suspend, demote, or discharge an employee for willful abuse of leaves, benefits, or misuse of a firearm. We didn't feel like this fit. It was a really strange, separate thing that was pulled out. Misuse of a firearm would likely be a misdemeanor or a felony, and willful abuse of leaves, benefits potentially lives in the leaves article. We also believe that for the majority of our employees, the misuse of a firearm would be handled potentially in a safety and security section, because those are the employees who typically are using a firearm work. Of course, there could be also misuse of a firearm off school property, at your own home, etc. But we thought it was strange to call that out separately from all other felonies and misdemeanors. In 10-4, we've made a couple of suggestions. In 10.4.1, all discipline, including termination, may be subject to the grievance process. We added in non-disciplinary actions, including but not limited to letters of expectation, are not subject to the grievance process. So knowing that that is part of the steps of communication leading up to potential corrective action, we didn't feel as though that would make sense for that to be grieved. In 10.4.2, we struck this because it's kind of detrimentally impact performance. Felt like this, if necessary, would be to live in Article 9 with performance management, if that's what it's related to. But also, if you read through it, because misconduct may detrimentally impact performance, the progressive process outlined in this article shall not be construed to be mutually exclusive. So sometimes misconduct will impact performance, sometimes it does not. Sometimes it's completely separate from an employee's actual performance. And so, we felt like it wasn't necessary to call this out in this particular article. In 10.4.2, an employee may request, instead of the word petition, it just seems like more simple language. An employee may request that their supervisor classify a corrective action step as inactive for the purposes of progressive discipline if no similar misconduct occurs within 12 months of the date of the first offense. Previously, the language was really ambiguous. It said after a period of time, so there was no specificity to that time frame. So we wanted to add in some specifics. In 10.4.3, this is simply stamping a practice that is already in play. The district may place employees on paid or unpaid administrative leave in response to allegations of misconduct, policy violations, or unlawful acts. And that is a current practice for any employee who may be allegedly under investigation for or have committed one of these particular things. And then in 10.4.5 or 10.4.4, employees participating in restorative conversations, administrative inquiries, and or grievance proceedings will be paid at their regular rate for the time required to attend. So this just really simplifies this language. It says the same thing, that employees would be paid for attending those meetings. We just modified the language to simplify it. And that is all in Article 10. Know that we have caucus time after all three articles. Are there any immediate questions that anyone on the team wanted to bring up? And Jen will drop that article into our.
Similar to how we are taking things and moving article to article, I just want to know it, because that's going to have a red line and it's just going to have strike through the portions that you would like to put into Article 9. How are we tracking that that's going to be moved to 9 rather than just striking? Just a process question.
I mean, we have a working draft of Article 9 also, and so we've literally just taken the whole section out and put it into 9, knowing that that is an article that I think you were bringing first, correct? And so I know that might be weird. So when you present 9, when we present it now, we'll exactly, we would put that whole section in there. And then if there are any red lines within that section, we would suggest we would put those in there as well.
Again, just how are we going to do process? Because we're kind of trying to do the same thing. So,
okay. Any other questions right away on 10? Great. Is everyone okay if we move on to 12? All right, Jen is going to present 12.
Okay, 12-1, we have changed most of the wording here to the grievance procedure aims to resolve concerns regarding potential violations of this agreement in a manner that is fair, formal, and timely, may be used exclusively to address alleged breaches of the specific articles outlined in this contract. And we struck what 12.1 was originally. We also moved from down below is 12-3 and legal general. We moved all of the definitions for grievances. So 12-1-1, we defined a grievance means a complaint made by an employee is defined in Article 1 or the JESPA alleging a violation, misinterpretation, or inequitable application of a provision of this agreement. We also defined class of employees, referring to a specific group of workers who share common characteristics, job duties, employment terms, or working conditions. We defined representative status, refers to the authority, role, or designation of an individual or entity to act on behalf of a group of employees in matters related to collective bargaining, grievances, and workplace disputes. And we defined neutral administrator to referring to a director level or higher who is not connected to the grievance, the department involved, or the specific incident in question. This individual is responsible for impartially overseeing the step 2 process. We also added, prior to entering into the formal grievance process, with the submission of the step 1 grievance form, the employee with a perceived grievable concern must first attempt to informally resolve the concern by meeting and discussing the issue with the administrator involved within 5 workdays of the incident triggering the concern. The employee will schedule time with the administrator providing a reason for the meeting. The employee may have representative accompany them to the informal meeting. Sorry, I'm having a hard time with that word today. And then we also changed or updated, the grievance process shall not be utilized to resolve complaints of unlawful, or discrimination. Instead, these concerns should be filed in accordance with the district policy GBA, Equal Employment Opportunity and Discrimination. We did strike GBAA because that is the level A policy that we have. For 12-2 for procedure, 12-2-1 step 1, we did change it from department level grievance. We're suggesting changing it from department level grievance to administrator meeting. We struck in order to initiate step 1 and how that will work too. If the concern cannot be resolved during the informal meeting with the employee's administrator, a formal grievance process may be initiated no later than 10 workdays after the informal meeting. In order to initiate step 1, the employee must submit a step 1 grievance form to the appropriate school department supervisor. A meeting to resolve the grievance will occur within 10 workdays. So with this, what we've done is we're suggesting that we add a level. The employee and the administrator will attempt to resolve the issue and may present or consider all available evidence. We also have added, we're suggesting to add 12-2-1-1, which is specific to a grievance procedure for hiring folders. Before initiating the formal grievance process by submitting a step 1 grievance form regarding an alleged hiring process violation, a JESPA representative must request and review the hiring bid folder within 5 workdays of the incident triggering the concern. For instance, failure to notify the employee in advance, failure to confirm an interview, or the hiring of another candidate. If after reviewing the hiring bid folder, hiring process violation is identified, the formal grievance process must be initiated within 10 workdays of review. Grievance must clearly reference the articles, clauses, or sections of the CBA that are claimed to have been violated. Explain how the action or decision conflicts with the cited provisions and includes supporting facts such as dates, times, and specific incidents. We are suggesting that we change all of the grievance must name the specifics to be more specific about what we would like to see. At the conclusion of the step 1 grievance meeting, the administrator will submit a written response on the approved district forms to the employee at the JESPA office, copying labor relations. We did change employee relations to labor relations throughout this document or within this article within 10 workdays. So we've changed, we are suggesting modifying the 5 workdays to 10. Responding to the issues. We are asking or requesting that the step 2 district level grievance be changed to neutral administrative hearing. And we updated to if a satisfactory resolution of the issue is not reached at step 1, the grievant, instead of JESPA, may initiate a step 2 grievance with the Office of Labor Relations by filing a step 2 grievance form within 10 workdays after receiving step 1. Step 2 form must explain how the step 1 response failed to meet the required requested remedies, otherwise it will be returned for revision. We also made some changes to the next paragraph. That states direct timing that criteria must occur within 20 workdays of the alleged violation. And that's when we step 2 agreement directly or less. That meet this criteria of the alleged violation instead of using offense in the event of an ongoing situation. We also made some changes on the following paragraph. A designated district administrator, district director level or above, unless mutually agreed upon with the JESPA, will serve as the neutral hearing officer at step 2 upon receipt of a properly completed and timely written request that clearly defines what remains unresolved as a result of the step 1 meeting to include the requested remedies. Labor Relations will schedule a step 2 hearing within 10 working days. And hold the hearing within 20 work days of within 20 work days of receipt of the step 2 grievance report. We also made requests to strike the first part of the next paragraph, and we changed or revised to at the step 2 hearing, the neutral hearing officer will consider all documentation and evidence submitted with the step 2 request, as well as the district's rebuttal evidence. Hear arguments presented by representatives for both parties and have the opportunity to ask questions. Neither party will be permitted to present new issues at the hearing unless mutually agreed to by. We also are making revisions to the next paragraph. The neutral hearing officer will furnish the employee, the JESPA office, the involved administrator, and labor relations with a written copy of their decision within 10, and changing that from 5 workdays after the hearing was held. The neutral hearing officer may be granted an extension for good cause by making a request of both the Office of Labor Relations and JESPA. And again, we changed 5 to 10. Step 3, arbitration. We have changed from transmitted in writing to submitted using a step 3 form within 10 instead of 20 work days after the JESPA receives the step 2 decision. We made modifications to the Office of Labor Relations or Employee Relations to the JESPA legal counsel assigned, and moved from 5 work days to 10 work days. And then as we scroll down, we also made a revision within the 5 work days here. We changed that to 10. And no public release of information may be made until after such a meeting takes place. So we just changed that. Here. And then 12.3, as explained above, we moved all of these definitions. In 12.3.1, we are suggesting that we have a grid that shows what type of grievance, what the timelines are, the time to schedule, and the time to respond. This will make it easier for the grievant and as well as the administrator. And then we just changed the numbering after that. Do we have any questions on Article 12? I'll make sure that I redline that 10 that I changed.
On 12 quite yet. We will move on to Article 13. Our final language presentation for the morning. So we have struck the very first portion of Article 13 regarding the training, and oh, I'm sorry, go ahead, Darcy.
And I'm sorry to interrupt, where it has that parentheses moved to PD article. That's the kind of stuff I was talking about on the previous.
Okay, just totally. Can on Article 10, after everything we struck around performance management, can you put that on there? Oh, perfect. Yeah, the same thing. Perfect.
Thank you. Great. That's exactly what and we actually have that later in this article too, that says move to appendix. So it's funny that you brought up appendix earlier. I'm like, oh, yes, good point. So, exactly, we're happy to continue with that practice. Sorry for the interruption. No worries, no worries. And so, to Darcy's point, this first statement we have struck, and our recommendation is to move into the professional development article. And that is really specifically because we believe that additional training and refresher courses that are required should be compensated at any employee's regular hourly rate, not just transportation employees, but NS employees, custodial employees, etc. So in this article, we have modified the numbering, and then our first change is down in 13.1.3. During the course of the contract year or school year, when a route decreases in time, previously it wouldn't give a specified time, and so we want to make sure that that is specific in here. In the third sentence here, it says additional work may be assigned to the employee to compensate for decreased time. Obviously, when employees are hired, our intent is to keep them hired at the rate and hours that they were initially hired at. Therefore, it might require that additional work be assigned if other work is decreased due to a route change or otherwise. Subsequently, in 3.1.4, we also changed from work offered to work assigned, and of course must be within the typical duties of the employee's classification. In Article 13.2, modification from 12 to 10, the district will continue to employ a minimum of 10 utility driver positions. As everyone is aware, we have a shortage, and being able to employ 12, I think, is becoming more and more challenging. In Article 13.3, we've struck this initial language and rewritten it down below. So this is around the Employee Administrator Liaison Committee. We've renamed it, and we have modified the language and rewritten the whole thing down. So 13.4 now reads Transportation Employee / Administrator Safety Committee. We acknowledge that safety is really important, both to you and to us, and to all of the employees and students, and as well as families that we support. So in 13.4.1, the committee will consist of one terminal director, one transportation employee from each terminal, one fleet employee from each department, one employee from the department, and one member selected by JESPA. So thinking that means one additional employee from the department in general. In 13.4.2, the committee will meet a minimum of 3 times during the school year. The transportation director or the committee may request additional meetings, which will be held during the school year. In 13.4.3, the committee will be an advisory committee, and the executive director of transportation will be the final decision maker. We've added in or changed the language around extra duty boards and labeled it that, and slightly modified the updated time. So extra duty boards will be available, updated daily, and posted at each terminal to allow employees to voluntarily sign up for an extra duty. And then I think that's the same. In 13, which would now be 13.6, special trips, we left that the same. In 13, what was previously 13.7, the full-time regular school bus drivers and school bus assistants who work for the district at a minimum of 228 weekdays, et cetera, we have suggested moving that to Appendix A. And to Darcy's point, we've indicated that right here. In 13, what is now 13.8 in our renumbering, vacant positions for school bus drivers and school bus assistants will not be advertised as described in Article 4.1. Vacant route positions will be posted for 3 days within the bus terminal. The vacancy has occurred. If unfilled after 3 days, the vacancy will be posted across all terminals. If still unfilled, the route may be awarded to substitute employees, should say a substitute employee, based on final selection criteria scores. Vacancies will be bid according to seniority.
Then we have struck that final language because it restates it above regarding when it will be assigned to a substitute employee. Under 13.9, we have been more specific with this language to include student safety equipment. And so with regard to student safety equipment, we have added in a couple of additional sections within 13.9. So in 13.9.2, all CDL and non-CDL bus driver and bus driver assistants, or bus assistants rather, are required to use the equipment per federal, state, and district guidelines, and that is documented in student safety plans. In 13.9.3, all pre-trip inspections will be completed according to the district transportation guidelines in their handbook, and all equipment malfunctions will be reported promptly. So of course, for the most part, bus drivers are dealing with equipment and how to keep kids safe using that equipment. And so that's why we've added these two in and made that more specific to what our hopes are for them to complete. And that is all in 13. Any questions on 13?
You go back to 13.9, the new one.
Of course, 13.9.
Just don't see that existing at all. So I'm just curious shouldn't that all be new changes?
This part was 13.9.1 was nowhere before.
It's not in transportation. I just want to clarify if I'm wrong, I will happily be wrong, but
No worries at all.
Okay.
It's probably a misread line.
all good. I just want to make sure we're tracking that as a.
Every once in a while, when you're typing in these, you're in edit, and then you're in suggesting, you're like, dang it.
We hear
You
you.
gotta go back and take it all out, so our apologies. Other questions on 13? I believe we have reached a point where we'd like to take a 20-minute caucus. Is that, yeah? And if the JESPA team needs more time, please feel free to communicate, let me know. And we have caucus rooms set up. Hopefully they're not cold. And otherwise, we'll ask Brandon maybe to push the button for us, take us offline. For those of you who are watching online, we hope you are somewhere safe. We have arrived this morning. Welcome to Tanya Lopez. Dr. Tanya Lopez, Director of Professional Learning, has joined us from the cold.